that's not. My Dean, Professor Kiari Amaura, Professor Austin Bukenya, who is making his way down to the audience, Professor Patricia Kameri-Mbote, Professor John Mugane, Dr. Collins Odote, Professor Sihanya, if he's here, and my colleagues. It is a big honor for me today to moderate a debate between two of Kenya's most eminent legal minds. In older good days, when debates were easier, I moderated a presidential debate involving 8 candidates. Please understand my challenge this morning, that I'm going to face 2 of the most brilliant legal minds in the profession of the law in this country, and also 2 of people who have served in very high places within the judicial system of our country. Now, interpretation of the Constitution. In the old days, and Professor Mbote did mention about Wanjiku. When I was a young journalist, and the KANU regime was tear-gassing pro-reform advocates, we found Professor Wanjiku Kabira, and we actually thought we found the Wanjiku Moi was talking about. I've been lucky to cover the transition from those days to all the way to the 4th of August, when the Constitution was ratified through a referendum. For those of you who are old enough, you voted in that referendum. And then the promulgation on the 27th of August, which I also covered. That day, we were told by our analysts that for those who missed December 12, 1963, August 27, 2010 was your moment, because it was a big constitutional moment. The nation was happy. It was going through a process of self-renewal. But it also counts that implementation of a constitution depends on proper and accurate interpretation. And it's also been said that the judiciary is the final authority in the interpretation of the Constitution. But there are other challenges, and I'm sure they'll be brought out in this debate, that include interpretation of the Constitution by non-judicial bodies. This includes players in Parliament, the executive, government officials, public bodies, authorities, commissions, institutions, and even public officers. I'm looking forward to hearing the take of these most eminent personalities in the challenges that are facing the implementation and interpretation of the Constitution. But I just want to go straight to the first question. The majority of us being law students, we want to hear from you, Professor Githu Muigai, Attorney General Emeritus, and you, the Honorable Dr. Willy Mutunga, Chief Justice Emeritus. My first question, and I'll give each of you about 5 minutes to make your opening remarks on whether there exists a theory in Kenya to implement the Constitution of Kenya 2010. What is that theory? Let's start with Chief Justice Emeritus, Dr. Willy Mutunga. The microphone is right there with you.
Good morning. Kwani hamuna sauti? It's always, great to be back to the law faculty. Actually, the only job I loved was teaching law for 8 years. But, you know, I was sacked and jailed. But that is part of the history of this faculty. Now, the first question, does the 2010 Kenya Constitution decree theory of interpretation? That was my argument when I was in the Supreme Court, right from 2012, and it's a theory you find in many of my writings, and also in the in the judgments, dissent and concurring that I wrote. And I want also to kind of introduce Miawa. Miawa, can you stand up? Maxwell was one of our brilliant law clerks in the Supreme Court, and he wrote this article, which is called the Genesis of Mainstreaming Theory of Interpreting the Constitution in Kenya, which you can track the cases and the arguments. But my argument was that Article 259 and other articles, the preamble itself, Article 1, which talks about the sovereignty of the people, Article 10 has already been discussed, values and principles. Article 20 is the one that also Professor Mbote discussed. 159, Article 2, Article 5 and 6 are important because they deal with international law, which is part of that, and maybe at some point, I'll talk about that aspect of international law that has been pursued by scholars, particularly abroad. Makau Mutua, Justice Ngugi, who is here. There's a group there that has been dealing with what they call trail, that is the third world approaches in international law, and Professor Gathi as well. They have talked about these issues. So, my answer is yes. There is the 2010 Constitution decrees a theory of its own interpretation, and there are reasons for that. And there are ingredients of that theory, that we can also discuss. And the most important thing, of course, is that the apex court, the Supreme Court, in the case of what was called the digital migration case, the Communications Commission of Kenya against the Royal Media and others, mainstreamed that theory. And if you're looking into the precedent value of that theory, now it binds all courts other than the Supreme Court, which can reverse, itself. AG, you are next, because that's the question.
The reason I became academic is because of Willy Mutunga. As I have told my students before, when I first came here 30 plus years ago, he was a bouncing young professor in his jeans and t-shirts and preaching revolution and the redemption of Africa and the world. And I was so intoxicated by that I owe him to this day. However, increasingly, as two independent academics, jurists, comrades, and friends, we have drifted apart. He holds a view of the Constitution that I don't, but my respect for him has never diminished even an inch. Does this Constitution contain a theory of constitutional interpretation? No, not at all. What does it contain? When you go to an art museum and see what Picasso has painted, or Vincent van Gogh, the mad artist, you attribute to the painting complicated things that never went through Van Gogh's mind at the time. He probably woke up, took a few whiskeys, and splashed his brush on the canvas. When we wrote this Constitution, because it was my great privilege to be there, I need to contextualize something. We came from a tradition where we believed, and history supported, that the Constitution had been abused, both by the executive, by parliament, by the legislature, and by other organs. We wrote a constitution to stop abuse. Everything that Moi had done, we wrote a provision to stop somebody from doing it in the future. We were so obsessed with that this constitution now contains several provisions that are unenforceable. What are we trying to say here? 259, we are trying to say, in the history of Kenya, the judiciary has been interpreting the Constitution in such a positivistic manner that it has become pedantic and nitpicking. And there is a lot of literature around that, the Dugdales, and a very conservative. In some of my writing, I say these judges were not conservative. They were subversive. They were subversive of the Constitution. They said things the Constitution didn't say. At one point, the court said, ridiculous proposition, that the Constitution is unenforceable because the rules required to be made by the Constitution for procedure had not been made, and therefore the substantive rule could not be enforced. That is not a conservative philosophy of law, that is a subversive philosophy of law. So we wrote 259. But 259 doesn't tell us anything we already didn't know. That we shall interpret the Constitution to promote its purposes, values, and principles. That we already knew. That's what every judge should have been doing all along from 1963. To advance the rule of law. That's exactly what judges should be doing. Permit the development of the law. That's what they should be doing. Contribute to good governance. This is not a theory of constitutional interpretation. It is an intention by a legislative organ to provide what, in its opinion, is guidance that will prevent subversion. Now, let me tell you something else that is equally shocking. The Constitution is not only a legal document, and if you read every page to give you a legal outcome, then you have missed something. The Constitution is both a political charter and a legal document. A third of this is poetry. If you go to page 1, which I wrote myself, I think Wanjiku Kabira, my friend, will confirm. I wrote this. We, the people of Kenya, acknowledging, honoring, respecting, committing, recognizing, exercising. That is not law. That is poetry. It is a part of the Constitution about how do we feel about ourselves? How do we inspire ourselves into? So if you look for law in the preamble, there is no law. And there won't be any law. So, what then would be a theory of constitutional interpretation? It would be this, and now I'll sit down. If you listen to the dispute within the American Supreme Court, that is a dispute about a theory of interpretation. The originalists contend that the whole Constitution is to be interpreted by asking yourself one question. What did the founding fathers intend on the year they adopted the Constitution? That's a very contentious question. There are others who argue that the Constitution must be interpreted from a textual perspective. You stay with the text, the language of the text, and the language of the text will yield the meaning of what the Constitution means. That is a theory of constitutional interpretation. There are others who argue about the structure of the Constitution. How is it structured? Because if you study the structure, you will study a hierarchy of institution and of values and of rights. That's a theory of interpretation. You can agree with it or disagree with it. There are others who have an ethical argument about the outcomes and so on and so forth. So let me answer the first part of the question by saying, I do not see in this Constitution a theory of constitutional interpretation. I see some poetry about how judges should generally conduct themselves.
Professor Githu has laid it out there, lifting the Constitution and saying he sees nothing in it that constitutes a theory. I'd just like to give you the opportunity to go into details of what you consider the theory. What are the ingredients of that theory? Please proceed.
I also have the argument that the reason why there is a theory in the Constitution itself is to make sure that the judges, okay, and that's what Githu was saying, you know, the various debates about originalism, modernism, you know, that you find particularly in the American Supreme Court is actually about the judges' intellectual, ideological, political biases. You know, so that in the Supreme Court of the US, the Supreme Court, you find judges who are said to be conservative, judges who are supposed to be liberal, radical liberal, others who are radical, and they are all in the court. So they have been given that, you know, opportunity to basically debate the theory within what you lawyers call the canons of interpretation. My view is that the 2010 Constitution, because of the history of judges interpreting either subversively, as Githu says, or conservatively, the Constitution, there was need to guard the 2010 Constitution against that eventuality. And that's why I think within the theory itself, all right, the judges, in my view, are supposed to be active and activists, because the Constitution itself is that. But I was asked to give the ingredients, and that has also been discussed. What is this theory, and what are the ingredients? I think Githu has said one thing, that the Constitution shuns staunch positivism. If you are doing jurisprudence, you know that debate. You've read about Hart. For example, the law is a law is a law. Law doesn't exist in the vacuum. Law doesn't have any role to play in transformation. that debate has a pleasant genealogy among lawyers and law schools, and but it's, I think now it's settled that, you know, law has a role to play in social transformation, and the Constitution plays that's role. So this theory shans staunch positivism. It accepts that judges make the law. That is Article 20. You know, the invoking of non-legal phenomena. It's when we say law doesn't exist in a vacuum, you know, we say that, and that's what the Supreme Court Act says, that you can go to history, you can go to economics, you can go to music, literature, another man of things in interpreting the Constitution. One thing that Githu said, which is also an ingredient of this particular Constitution, is the objective of the Constitution, broadly speaking, is about subverting a status quo that we found unacceptable and unsustainable. Okay? Basically, if you want to bring it to talk about it briefly, is what Moi used to say, siasa mbaya, maisha mbaya, which is that status quo that we grew up ourselves seeing, serious dictatorships, the right to vote being subverted, you know, the whole gamut of human rights, resources being stolen, everything that you can think of. When you look at the Constitution, it's about changing that status quo. And that's why the notion of transformation is important. Now, the reason why we say there's a theory is that when you look at it, it's a merger of paradigms that problematize, interrogate, and historicize all paradigms in building a radical democratic content that is transformative. Within the Constitution, people talked about law in context. You had the critical legal studies. You had the Marxist theory of state and law. You have ingredients, you know, of all this within the Constitution. The bringing in the non-legal issues, the values, for example, the view that this theory says that the Constitution is not legal-centric. So you're not going to be using the Black Law Dictionary to basically look up the meaning. It's more than that. It calls for a multidisciplinary approach, you know, to the implementation of it. And all these are giving ingredients. It's not insular or inward-looking. Okay, it's a theory that says very, very, very clearly that we can build a progressive jurisprudence that we can export to other countries in the South, in Africa, and globally as well. And that international law itself, we can influence in shaping it and developing it. That is all, you know, within the theory. And I say very clearly in my writings that I derive it from the provisions of the Constitution and also the Supreme Court Act, 2011. So it's again to repeat that it denies, in my view, resort to by judicial officers to the common law canons interpreting statutes and constitution that allow officers in doing so to routinely reflect intellectual and political biases. And if you read Githu on judicial review, it's clear. He's also saying stick to the constitution and not use these canons. If you read Yash guy, who I quote at some point, this is what he says. He says the reason why there is this theory, and he agrees with it. He agrees there is a theory. He says perhaps realizing its own ambitious project and ends the vulnerability and fragility the Kenyan Constitution sets through the judiciary, its barricades against destruction of its values and the weakening of its institutions by forces external to itself. And such is the responsibility of Kenya's judiciary. The other scholars who, not Kenyan ones, if you read what a guy called, a great professor in India called Upendra Baxi, he goes into this issue of theory as well, talking about the Supreme Court, talking about judges, and politics.
First, I want to affirm that everything CJ says about approaches to constitutional interpretation, I would concede. I would concede that the Constitution must be interpreted holistically. If we ever didn't do that, then we were very negligent. Every statute should be interpreted holistically. Every statute should be interpreted to be purposeful, to give effect. If there is a Freedom of Information Act, you must interpret to give freedom to information. So I concede everything that CJ has said. But I want to come back to why do we need clarity? Why do we need clarity on how to interpret the Constitution? Why should we be very, very worried of wooliness? Why would we be worried if our judges were woolly? It is because a theory of interpretation should be logical. It should be logical. Even the lay person who hears this outcome of a case should say, that makes sense. It is logical. It is consistent. It is coherent. It is predictable. It is objective. This is what the very old teachers of law, now discredited, like Lon Fuller, were teaching 90 years ago. They were teaching the inner morality of law. Law must have an inner morality. It is that inner morality that allows fidelity to law. If there is no fidelity to law, a judge is a loose cannon. When he wakes up in the morning, he says, I want to advance the ends of democracy. Kenya is a backward, underdeveloped democracy. I, Mr. Justice Kamau Wanjoroge, I want to advance the frontiers of democracy, not his job, above his pay grade. The frontiers of democracy have been codified by the Constitution to be extended and defended by elected officials, whom the people periodically call back and say, we heard what you said in the House, you don't represent us. One of the most important arguments against an activist judiciary is because the judiciary is counter-majoritarian. Who elected them? With all due respect to my teacher, but we are now talking the theory. Who elected judges for them to decide Parliament is full of idiots? And I, Mr. Kamau Wanjoroge, must protect the population of Kenya. So Parliament has said in very clear black letter law, no person shall be eligible to receive higher education loans if that person has not demonstrated A, B, C, D. Parliament is making policy choices that politicians ought to make. We have a judiciary sometimes that says, Mr. Minister for Transport, you have said you have burnt matatus that have more than, that have less than 14 passengers. That's not good. Why don't we put it at 7? That judge is not interpreting law. He's not defending democracy. He is an outright loose cannon. He has no such power in law. Now, so for me, what scares me is that you can have a judiciary that is activist in both directions. During Moi's time, a subversive judiciary would say the president is above the law. You cannot question a minister. And it would go on and on and on. That is very scary. But today, with the same set of progressive tools, you can have a judiciary that says it will make law, it will override parliament, it will override its own binding precedent. Let me give you an example, which may probably show you how dangerous this is. A week ago, the High Court in Kenya made what I thought was an amazing declaration. It stated that the penal code provisions on what some broadly are called anti-sodomy laws are not inconsistent with the Constitution. To my mind, I entertain no doubt whatsoever that that is not an interpretation of the law. It is a baggage of inarticulate premises. Either they come from religion or custom or culture or whatever, but they have nothing to do with the interpretation of the Constitution. Because this is what the binding Court of Appeal precedent on the matter says. The Court of Appeal stated that a physical inspection of a Kenyan to determine whether or not they had participated in an unnatural act was unconstitutional. That law is not changed. For the High Court then to say that there is sex against the order of nature which can be determined not to invade the privacy protected by the Constitution. In my view, that is precisely the sort of judicial activism in the opposite direction. So what do we need to do? We need a theory of interpretation that is pragmatic, that is consistent, that speaks to the canons of interpretation that we can critique because they are objective. Let me finish by saying, what worries me most about the Supreme Court today And I have said that to the Supreme Court the number of times I have appeared there. The Supreme Court of Kenya does not recognize any other law other than the Constitution. Every question is answered by check article this. My own argument as an academic and a practitioner is this. The Constitution itself recognizes that it's not a land law statute. Is it a land law statute? Is it a family law statute? Is it a company law statute? Is it the statute controlling criminal procedure? Is it the statute controlling civil procedure? It is not. So it is not an answer when the question is raised, where is the locus? Locus is important. The court is not a marketplace. You cannot say everybody can approach the court. It is even irresponsible. There is the economics of justice. We must be able to go back to a statute that says, how does the law of Kenya recognize that you can approach the court? By petition, by plaint, by originating summons. The Constitution cannot rewrite that. You cannot then go and say, you know, the Constitution recognizes that I have a right to be admitted to the university. Okay, so what have you filed before the court? I have written to you, Mr. Judge, a letter complaining. If we go down that road, in my opinion, we will not grow the law itself, which is parasitic on the Constitution. I used to tell my students, time has not changed my position on that point. If we can think of 100% of the law of Kenya, the Constitution is 10%. The Constitution itself recognizes that 90% of the law will be in the Dog Act, the Cat Act, the Donkey Act, the Maize Act, the Bean Act, and a million other statutes. And if it wasn't there, this would not be enough to govern our country. So I summarize by saying, therefore, a theory of interpretation of the Constitution should be minimalist, not maximalist. It should be a minimalist, not a maximalist interpretation. It is one that confines the Constitution to giving life to provisions. Let me give my last example, which I gave last year, Mr. Moderator. There are many people who say you can read this statute, this Constitution, to support gay marriage. I say it is nonsense on stilts. There are those who say you can read this Constitution to outlaw the death penalty. More nonsense on stilts. That's not my original language. That's the language of Bentham, whom you will meet or have met. Why do I say that? Because the issue of gay marriage was debated by us. Wanjiru Kabera will confirm. It was before Bomas. We debated it, and we lost the motion. So we cannot have a constructive way of reading the Constitution to legalize gay marriage. It means we are being dishonest. I am a great exponent against the death penalty. I argued for us to remove the death penalty. Many people supported that view. We lost it hands down. We can't creatively now come and read a provision that we lost on the floor of the assembly that voted on the Constitution. When I was Attorney General, a case was filed challenging the mandatory application of the death penalty without a judicial process. I supported it completely, and it's the law of Kenya now. And all death penalties are being reviewed. today. So I would say, therefore, that a minimalist theory of the interpretation will save this constitution for longer. A maximalist, that it provides for everything and anything, anywhere, by anybody, will kill it before it has started crawling.
You heard Professor Githu arguing for a minimalist and not maximalist approach or theory of interpretation. Earlier on, he also spoke about an activist attitude in the judiciary. Please respond to that.
Well, you know, I had a debate with the current Speaker of the National Assembly when he called me an activist, CJ. And I told him that he was also activist. Actually, all of us are activists. It depends on which cause you are activist in. We're all active, right? So I told him, you know, you're an activist in pushing, which he has continued to do, to subvert the Constitution through, you know, legislation. So the issue of the activism in this country tends to be given, to be used as a dirty word. But as Githu says, it has two faces. And we are all, you know, activists. I basically think that, you know, within this theory, judges play politics, and they should. Within this particular theory, because you're going to, when you interpret values and sustainable development, patriotism, etc., you have to leave the comfort zone that lawyers have by saying they are learned when we are very ignorant in other disciplines. So you have to move into politics, you have to move in philosophy, and that's why I said interpreting the Constitution, this theory states very clearly that this document is not legal-centric. It's multidisciplinary. There's one issue that Githu will have to take note of. The question, who elected the judges? Actually, when I was the Chief Justice, I thought under Article 1, you know, I had the authority of the people delegated to me, okay, because judicial authority derives from the people. I also thought I was elected because when I was interviewed, you know, all the natives were asked to come and vet me, see whether I was suitable. And they did. And you know what? I was also nominated by the guy you now call Baba and Chibaki, it's the Ugandans would call him. And those guys had won millions of votes during the 2007, you know, election. They thought, you know, I could, you know, so, and then I went to Parliament, you know, where the pigs were. All, you know, they told me, yeah, this guy can be Chief Justice. So I know this argument about election politics. Judges must stop saying that they don't do politics. Because even Githu has said in the dark days, and he was quoting Chief Justice Miller, who was supposed to operationalize the Bill of Rights. And he said it's not operative because I didn't do the rules. So why did he do the rules? And Dugdale, and there were quite a number of others who did that. So the Constitution allowed judges to be activists within its provisions. Within its provisions, in my view. And that's what the discussion about transformative constitutions that is for another day, because we should have started with that. You know, this notion of transformative constitutionalism, you know, what does it do and how does it move beyond what Githu is saying? That's something, if you get all the papers that have been given you, you'll be able to, to get it there. In terms of...
Let me just interject, Dr. Mutunga.
Yeah, I just wanted to finish this thought. Okay. In terms of, Githu is saying the theory, will have to be redefined and whatever. The Supreme Court has given, okay, very, very, very clearly what, the theory will be. I'm 1,000 miles from arguing that it cannot be refined. I expect Githu, because he was arguing in the Supreme Court about this issue, that he will go back to the Supreme Court and convince the Supreme Court that there is no theory and this is how we have to do it. But I agree with him that like everything that you come up with, you cannot say it's a be-all and end-all, right? It still needs refining, and there are people who have problems with it, as Githu has actually showed. But that is for the the Supreme Court to do. But as we talk now, that is the law.
That is
by
the law.
Apex Court.
Yeah, my interjection is just about something else that Professor Githu raised, to which I would like you to respond.
Yeah.
You've spoken in defense of judicial activism.
Yes.
How far does that have to go before it becomes what he called loose cannon?
Well, I don't know what a loose cannon is, but I don't know. But if we accept, and this is really the crux of the matter, the crux of the matter about the Constitution is challenging some dominant paradigms that in law schools, as we practice law, we've accepted because of our colonial heritage for decades. Oh, okay, so the Constitution, when we say is decolonizing, when we say is indigenous, we're just using words that have been in the Supreme Court Act and the Constitution. But I think the Constitution has its barriers. It has its barriers against rogue elephants, and the loose cannons. In fact, I think without this theory, that's when you get more loose cannons and more rogue elephants and rhinos, then the situation where we refine, okay, a theory of the Constitution and say these are the ingredients. We say, as we did in the case of digital migration, where we face a situation where the Chinese were going to get all the spectrum. And so we went back to the Constitution, and that's why I think it's very important to go back to the Constitution. And we use the value of patriotism, sustainable development, and we said it can't be said that the 40 billion assets by Kenyans will just be wasted and we give the licenses to the Chinese. So we used the Constitution, the values in the Constitution, Article 10, to talk about inclusiveness, to talk about equity, equality, accountability, to basically say what sustainable development means is that domestic investments have to be respected as much as foreign investment. So my view always was, if I got a case from Australia or from America, I'll interrogate it using the Constitution to see whether it subverts the Constitution, its values and the ingredients, of that theory. So I don't agree that the Constitution it's a supreme law. Okay? And that's why Article 20 says you can make law. You can, and we had that debate in the Supreme Court where some of my colleagues thought there's a judicial practice or judicial notice that can subvert, the Constitution. And I was arguing, no, Article 20 says if it does subvert in terms of Bill of Rights, you interpret it, you develop it so that it complies. So I see the Constitution as really the crucible to make sure that is the reference point on all that we do, and I think that's how the judges will be kept in check. Not to also say that there are provisions for removal, misconduct, incompetence, judicial laziness, and mental infirmities, judicial mental infirmities, and so forth. So there are procedures for dealing with, rogue judges. In my view, they will be removed, and there are examples of that have happened in the judiciary.
Yeah. Linus, will you allow me just half a second to respond?
For a minute, 1 minute, please.
Okay. When is a judicial officer rogue? When is a judicial officer a loose cannon? If 3 days, 4 days to a national election, a judicial officer says, I am overturning the decision to award the tender to print the electoral papers because, listen to this, because there was no public participation. That is not an interpretation of law. That is a dangerous flirtation with politics.
Thank you. You want to respond to that?
Yeah, but if we can leave politics to hooligans in parliament, why not people who are learned, lawyers who are in the judiciary? That would be my whatever. We cannot really, and I've been arguing, about this issue. I've given lectures about this issue of judge and politics. We basically are we are politicians. It's not that we don't say it. We don't say it. And you see, the example Githu is giving, public participation is a value. The courts themselves have said what that public participation entails. All right? If it's the case of Odunga, for example, I think that's what the one you're quoting, Githu?
There were several, sir. And public participation is within the statute itself. Well, if we were to go that way, Chief Justice, it would mean that somebody says, students have been admitted to the university, they should be blocked from reporting because there was no public participation. The University Act has no public. The truth is this, good ideas inside the Constitution are being cannibalized to justify inappropriate political interventions. That's the real danger.
Yeah, but I still think that what Odunga and others were doing is look at again the word public participation and breathe life into it. All right? And it's the guy called Kiboko Yao, Baba Yao in Embu, called a meeting via Twitter. He just said there's going to be public participation, therefore Twitter, come to a meeting. And Odunga was saying, wait a minute, we have other forms, barazas, people can be called to a meeting so that they participate. My governor in Kitui, Ngilu, for her, public participation is addressing a meeting of hired crowds. And he said, we have decided. But for me, public participation is tied up with the issue, Article 1, which is the sovereignty of...
And I'll give both of you, Dr. Mutunga and Professor Githu, just a minute each to comment.
Yeah.
Now that you've raised the decision by Justice Odunga, I'll give you another Odunga decision that I would like to hear your comments on. And that is on the case of returning officers just a day to the next election, when the judge actually made a decision that the returning officers were not procedurally appointed. And what that would have meant was the election should not have proceeded. Would you support a decision like that?
If it was done within the Constitution, I would support it. You know, the other argument is we are saying some politicians can make certain decisions, or some people want to go into election and they tell us, oh, if this decision is changed, it will be expensive. Okay? I think that's a dangerous argument in Kenya, you know, coming from thieves and the people who are, you know, who actually corrupt. They are mounting national debts and so forth. That's a bit Githu doesn't want me to say, but that's my activism. I've had it since the 70s. I basically think that the Kenyans themselves, since they have told judges that they exercise the authority from them, they should be allowed to make that decision. And that decision, in my view, under the Constitution, has the force of the Constitution. And if the executive is aggrieved, it has to go to the Court of Appeal as it did. That is it. If we don't want to subvert the Constitution, once you get a bad decision, you have to appeal. But if you don't appeal, it's a subversion of the constitutional rule of law not to obey it.
You are 1 minute on the Khalifa case.
Again, we go back to what should a theory of interpretation contain. In my book, it should be prudential. A judge is prudent. What is it you are curing with your order? Is the order likely to cause more harm than the harm that already exists? A court order that says the election is tomorrow and we have nullified every station in the country, and if the election is not held tomorrow, the Constitution contains no provisions for expanding time. Therefore, the effect of my order is to create a constitutional crisis of monumental proportions that will require a constitutional amendment to be effected, but the House that can effect an amendment has already been prorogued. To my mind, that is not a prudential judgment. Let me give you the example of a prudential judgment. Not so long after the new constitution came into force, it was realized that the budget estimates had not been published in accordance with the provisions of the Constitution and in time. A person went to court and said, this entire budget process is illegal and unconstitutional. The consequence of that was going to paralyze the whole of government for the foreseeable future. A judge, a very, in my view, and I take no credit in having trained him, but clearly, on his argument, which is the prudential argument, was this: that is correct. That is what the Constitution requires. But this is for directions. It is to direct a process so that the process achieves openness, transparency, and so on. To reverse this process would cause greater harm to the Republic of Kenya and its people than not to do that. That is my kind of judge. A judge who then says, I am applying the law, I don't care about the consequences, it's for politicians to worry about the consequences. That judge is not a judge, is a politician.
Thank you, Professor Githu. And among other decisions that also posed interpretational challenges was the presidential nominations and the presidential election of 2012. The date had to be subjected to a court process in terms of interpretation of when it should be held. The Constitution spoke of and speaks of to date the first Tuesday of August. We ended up having the election on the 4th of March. I now want to go to the audience. Please, by show of hands, I'm going to give you the opportunity to ask one question and specific to either Professor Githu or Dr. Mutunga.
They can also make comments.
My question goes to Professor Githu Muigai. My name is Miyawa. And I want to challenge you on this. Don't you think it's too dangerous and even preposterous to propound a theory, a minimalist theory of constitutional interpretation, particularly in the context of what we now call a transformative constitution? The reason why I make that argument is this, that minimalism, as opposed to maximalism, comes with the inherent dangers of being restrictive, being narrow, and does not take into account multivariated phenomena. And for that particular reason, and for that particular reason, to propose a minimalist theory that not take into account different context comes with the baggage, what you call the baggage, or a dangerous flirtation with the non-indigenization of law, because our law has to be vernacularized to reflect context, to reflect different diversities, whether ethnic, political. So minimalism, and especially because the legal interpretation we rely on in this country is that of the received legal tradition. And the received legal tradition is very dangerous. If you read very keenly the work of Etienne Murenic, who proposes a transformative interpretation of the Constitution. Actually, he even calls it a post-liberal constitution, because liberalism has got its own inherent danger that we cannot go into today. So I want to challenge you that it's very dangerous to propose minimalism, because minimalism comes with restrictiveness and narrowness.
Thank you. Professor Githu.
Well, I must confess that most of the words you used, I did not understand. Having said that, I think both of us recognize that the Constitution must serve a purpose. For me, what my experience teaches me, and I could be wrong on this, and my students are always suggesting that I am wrong, but they don't articulate it because of our friendship. What is my appreciation of what the Constitution should do as a jurist? In my view, the Constitution should stabilize the political and social order. If it doesn't do that, it is of no consequence. It's a piece of paper which every 2 years we will write, we will throw it out, a new group will come, we will write a new one and throw it out. I teach my students that the 60 solid years of uninterrupted constitutional rule in Kenya is more important, in my view, than having a transformative constitution in the mold of the South African Constitution, where you have a piece of paper that has absolutely no relationship with the way the people live. Okay. So you have Mandela's transformative constitution, and what does it do? It masks racism, it masks xenophobia, it masks the largest inequalities among human beings anywhere in the world. So we either want fact or we want rhetoric. Either fact or rhetoric. For me as a jurist, I have made peace with incremental change that stabilizes politics, that stabilizes society, that stabilizes cultures, so that my grandchildren will still be walking around with this constitution with a few changes inserted there, as opposed to a maximalist that would have thrown out this constitution 5 times and brought 5 other groups to write it. What do I do when I am confronted, like one of my pet subjects, what do I do when I'm confronted by, say, polygamy? In Bomas, my mind was absolutely clear. If we wanted to abolish polygamy, we were going to lose the whole constitution. If for no other reason, because of Joseph Martin Shikuku, who would not countenance that. When I went to Sharia House as Attorney General and we were pushing the marriage bills, and I was being pressurized by my good friends like Panjuro Kabera and Patricia Mbote, and I was saying to them, let us listen to the wisdom of the Luo nation. This is where we go mos. We are going to get there, but you will not change society by imposing it on it a social value that it has not accepted in the name of maximalist. I rest my case.
And to something else he raised there that I just want to follow up. He basically argued that the words minimalist and transformative is a contradiction, isn't it?
Yeah. Do I want to transform Kenya? Oh, in the fullness of time, I want Kenya to be transformed. How do I want Kenya when I am an old man of 120 years? How do I want to live it? I want to live it an independent country without social inequality, without oppression, the equality of genders, the ability of people to define their sexuality. I see a huge dream of what Kenya can be, but I'm old enough to know that if I want that yesterday, I'm a fool.
Let's take a second question from right here. Thank you. Your name and a very quick question or comment.
Thank you so much. I'm Oliver Irupe. Professor Githu, if there is no constitutional underpinning in our constitution, as you denied in your first statement, where do we bring the minimalist interpretation at this time to the constitutional making in Kenya, whether by the judiciary or any other body, including parliament?
Does the Constitution mandate a theory of interpretation? My answer is no. Does the Constitution, in very broad terms, express a desire as to how persons interpreting the Constitution should do that? Yes. Is it different from what we had ever used before? No. So if you were talking to an American lawyer and you asked him, what theory of the Constitution do you subscribe? There is a person who can tell you, I subscribed to the doctrinal argument. That's what I'm saying. That is a theory about interpretation. But if you said to him, I believe it should be purposeful, he will say to you, that is not a theory about interpretation. Yeah? That is an approach to interpretation that is inherent in the judicial making process in any event.
Thank you. Let's come to Professor Mbote here.
I'd like to raise a question with the Chief Justice Emeritus. If indeed there is a theory of constitutional interpretation, and the Constitution also says how you're going to get the officials of the court, how is the theory of constitutional implementation carried through in the bringing the people that actually interpret the Constitution? And how is that read with conflicting issues, such when you talk about regional balance, you talk about diversity, and then there is competence. How do you marry all this to ensure that the people you have actually carry through the theory of implementation?
Yeah, okay. It's a good question. You know, the vision of the Constitution about that issue was that the new judiciary was going to constitute, all right, people who are subjected to the new Constitution when they were recruited, all right? That is after the promulgation. But those who are in were subjected to vetting on the issue of, issue of suitability. And I think everybody knows here that there was this board, Judges and Magistrates Vetting Board, that worked for 4 years, dismissing or saying some judges were not suitable, magistrates, for various reasons. The Act itself gave a criteria, comprehensive criteria of judging the suitability of judges. So the vision of the Constitution was, after you vet some, and then the others who are coming in and who are subjected to the new Constitution, you will have, a new judiciary, a judiciary that has integrity, that is incorruptible, that is competent. And that's why the Constitution also said that we can get judges from the academy, we can get judges from the corporate sector, we don't just have to get them from the judiciary and the lawyers. So the collective intellect that was going to come up in the judiciary was going to be very, very important in developing this jurisprudence. And there were other administrative activities that were born of this particular theory. For example, the Judiciary Training Institute was about this aspect that we needed to have a theory, or if you want to use Gil's words, approaches. We needed to be very clear as a judiciary that this issue, was settled. But as we talk now, the judiciary reflects this debate. Okay, there are people in the judiciary there who are Githu students and the mentees, and the others who actually, believe that this approach is right. And I think going forward, it's the Supreme Court that will have to, to deal with this case, that because it has mainstreamed the theory, rightly or wrongly. But that's where it can, it can be changed. But we worked administratively, towards that goal in the judiciary transformation framework. We realized, for example, that we needed to be educated, by other disciplines. When we were doing the digital migration case, I had never heard of spectrum. I hadn't heard of it. So we needed scientists to tell us what it is. Why is it infinite? And you get a lot of, education there. We brought in people who are literature giants like Kabira and others, and you find in the judgments, we started, bringing in a lot of these issues, quoting Ngugi, using Sheng words, utadu, judicial utadu, mtadu, and Swahili instead of Latin, which I don't understand. it's a process. I agree with Githu that it's a process and it's a very healthy debate. But we should not disguise ourselves that this debate is not ideological and political. That's it. Because when we basically say that law doesn't exist in a vacuum, that's what we mean. The theory doesn't exist in a vacuum as well.
Thank you. We'll take 2 more questions from the front, and then we'll go to the back. We would like to take questions from the students as well. Yeah.
Thank you very much. My question is, in August 2010, we were all very happy. We danced and we celebrated the birth of a new constitution. A new dawn is what we called it. We were celebrating an opportunity that us as Kenyans, we finally had a chance to develop homegrown jurisprudence that was African, that was Kenyan, and that we could actually own, and that was different from the colonial past. To what extent have we been successful 9 years down the line?
Thank you. Can I start with Prof. Githu on that one?
Well, I personally take great pride in this constitution. I think it's a good constitution. It has helped us to achieve things we hadn't achieved before. I think devolution is a fantastic idea. It's not working 100% the way we would want. My CJ is right to say a lot of money is being wasted, it's being whatever, no problem. But I think it has changed forever how people access resources, how people are governed. I think that's a very, very good thing. I think our rights culture has improved. We have swung from a situation where the executive held the predominant advantage on allocation of rights. Now we are in a state where I believe myself that many of the fundamental liberties provided here are accessed by many people, not by everybody. There is much more that can be done and should be done. And so to that extent, I'm proud of it. But a word of caution. I think that those of us in the business of law sometimes mislead the general public as to what law can do. And I like to say to my students, non-lawyers have more faith in law than lawyers do. It's just like medicine. Many doctors have less faith in medicine than we ordinarily as laymen do. And I can assure you that there are many doctors who walk to the bedside of a patient every morning, find him alive, and they are totally shocked. There is a limit to what law can do to transform societies, because societies are more complex than you can't decree. You can't decree to a society, please wake up, be democratic, walk away now, and never be totalitarian again. The culture of totalitarianism is a culture that is within the fabric of how societies are created. And I can ask you, like I ask my comparative constitutional law classes, why do you have a decolonizing constitution? The British used the same decolonizing constitution in all their colonies, from Jamaica to Barbados, to India, to Pakistan, to Zambia, to Kenya. Why do these constitutions create such different societies? Why is India the largest, most shambolic, most chaotic democracy in the world, but it still holds 9 days of elections? Next door, Pakistan, decolonized with the very same piece of paper, a military dictatorship that has no chance of ever changing to anything different. It is because the underlying culture that irrigates the Constitution is as important as the Constitution itself. And I don't want to mention some friendly countries around us in which we all know that the Constitution changes every year because there is a new imperative to keep the leader in office every year. Okay? And so, I hope, Dr. Nkatha, I have answered the question that this is a good constitution. We are making progress. That's why I'm a minimalist. Every day we take steps. Every year, every decade we take steps. Don't be too harsh on yourself. We cannot transform society without transforming the culture. Let me say this because it's one of my examples that I give my students. When we went to Kisii to discuss the future of the Constitution, we met groups and groups of people who said, FGM is not on the table. Have you understood? That is not on the table. And I used to like telling this, as I interacted with, that Jomo Kenyatta went to London in 1927 on behalf of the Young Kikuyu Association with 3 demands: the return of the Kikuyu land, the right of the Kikuyus to educate themselves and their children, number 3, the right to Kikuyu FGM, 100 years ago. So we must understand what is it law can change and what is it that law must work with the culture to change. Thank you.
Dr. Mutunga, and just a reminder of Dr. Nkatha's question, it was on development, the opportunities to develop our own jurisprudence as a country, and it's been many years later since 2010. What is your take?
Well, the way I look at, the way I would like to answer that question is to look at the implementation. And I think the implementation has been a contested terrain. Okay, because there are forces who don't want the Constitution implemented. They don't want us to breathe life into the Constitution. And everybody knows, that this is a fact. And the struggles are continuing. And there's now a lot of talk about the changing the Constitution itself through the, I think it's called what, building bridges to nowhere. So and other groups that want to change it, and they don't want to follow the process that we followed, because Githu was in a constitutional commission, right? There was another commission that gave us this, this constitution. So if we wanted to change the constitution, my view is we can take audit of it. I still strongly think that a lot of you who are here did not write this constitution. And you might have your own version of what the constitution should look like. People, 2000 or whatever, a lot of you are in your 20s, right? Yeah, so you didn't vote for it, you didn't write it. You might have your own views about it. So if you are going to change it and we're going to audit it, we really need to use the process that we have always used, and I think that's important. But having said that, even devolution, which is a great pillar, is being subverted. Once we look at the Constitution, in my view, I think if we are going to have a reflection on it, it should be within the processes that give us the chance to discuss it, rather than having changes which, for me, I think are the cause of our problems in this country. People don't want to say this. Our problems politically are caused by the big five, not the animals. The 5 communities decide who is going to be president through alliances and so forth. They don't have the intelligence to rotate. If they were rotating, the Luos and the Kambas and the lawyers would have also been president, right? and maybe we'll be very stable. But we have people who decide when we should fight and when we should have peace. And I can't trust that kind of political situation to come up with a constitution. It will just subvert it. So we need, in my view, particularly the young people, to basically say what you also want to see in the constitution. There are rights in that constitution which are very, very important if they are implemented. Education, the right to work, housing, the right to food and so forth, if they are actualized, they're very, very, very critical. But who is going to breathe life into it?
Thank you. There's one more question from this side, and then we'll go to the back. We're coming that way too, yeah.
Good afternoon. My name is Ogada. I'm an alumni of this school and a practicing advocate. From the onset, I have to be clear in my mind that the problem with the Constitution and constitutionalism in this country is one, parallelism. That we have a constitution and edicts flowing from the Constitution, but nonetheless, deep state vested interests have decided to create a parallel system to overshadow and undermine the Constitution. So that we will go to court, prepare applications on the basis of Article 25, habeas corpus, get somebody out, but deep state, the powers that be, will decide that so-and-so will stay in there. We are the power holders. Now, in terms of whether the Constitution espouses a theory or not, I'm a firm believer of the Mutunga school, in the sense that a theory being a supposition or system of ideas intended to explain something will mean that Article 259 of the Constitution, which demands that meaning be given to values and principles within the Constitution, preeminently Article 10 being a salient exposition of the same, will mean that in giving meaning to the values and principles, then therein lies a diktat, an imperative to explain and give meaning to certain norms within the Constitution. Therein lies a value. If you look at Article 24, in its demand that a certain core to rights must be maintained in interpretation, there lies a minimalist understanding of a theory. So we cannot escape from the understanding that the Constitution bears a theory. Our problem, and I maintain, is deep state, a purposed understanding to undermine the normativity of the Constitution.
I am Mercy and a student of UoN. My question is based on interpretation. We've talked much about the law and language. My scope is in the perspective of the language in law. According to the Constitution, it's stipulated under Article 7, 6, 35, 164, 250, and the articles goes on and on, to which they have redirected that the interpretation of the Constitution in terms of the rules and laws stipulated can be in either English or Kiswahili. And it further promotes and states that the judicial officers and the states should encourage, develop, and promote linguistic rights in the perspective of Braille, sign languages, indigenous languages, and I suppose the local languages. To that, I may be corrected. So my question is, what are your views in terms of interpretation of the laws? The laws that we see here, people don't seem to come to an agreement about. How far can we develop them in terms of even publishing a Kiswahili constitution, katiba in actual sense? How far can we go to putting out there a constitution that is in sign language, in the Braille, all for the purposes of the national values articulated under Article 10, inclusiveness? transparency and equity. Thank you.
Okay, both of you will take half a minute, starting with Dr. Mutunga.
You know, I think it can be done. You know, we've been talking about the Constitution, and we forgot that one of its major pillars is equitable distribution of resources, making sure that the resources are not wasted and they are not stolen, so that they can be used. But I also think that, and I always want to give this statistic, the people who go to formal course in this country are only 5%. Only 5%. The others don't. You know, and that's the 95% go to other forums for the adjudication of justice that they trust. And the issue of language becomes very, 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 very important. If you sit in a dispute in a village, you understand this readily. The fact that they are speaking the same language, the fact that the women and men who are supposed to adjudicate are known by the people in the village, and they expect, you know, they will get justice and so forth. So I've been talking about breathing life into the Constitution. The resources are important, okay? But I've said also that the process is fundamentally political. So what we've done, in my view, and Professor Kibwana tells me this all the time, he says that the Constitution is a baby, you know, which we have actually handed to rapists and murderers, and we expect the child to live. And that's the political thing that I've been emphasizing, that maybe with an alternative political leadership, you know, we can breathe life in the Constitution because it has hallmarks of progress. But if it's in the hands of people who don't want that progress, who want the status quo, you know, because that's our material interests, it means we just have to struggle against the status quo and make sure that the Constitution is implemented. And the stuff that you are saying is, you know, personally I think it can be translated in Swahili and other languages. In the 90s, when we had a model constitution, it was translated in other languages. Even now, the Bible, you know, is translated in virtually every language, and I see now the Quran. The other day I got a book, you know, Quran in Kikamba. So we should be able to, you know, to translate the Constitution, because I've always thought that the Constitution rests very neatly with the Quran, the Gita, and the Bible.
Very briefly, Professor Githu.
I would support translation into Kiswahili. I would support a Braille Constitution. But I think we should not get ahead of ourselves. We must do it on a need basis. Part of the biggest problem we have with this Constitution is that we sat down and dreamt things, and they looked beautiful, and therefore we wanted them. Today, they've come back to haunt us because we can't afford them. We have a Senate that does virtually nothing. But it was a beautiful concept. It was the idea of a house that would supervise Parliament and defend devolution. I leave it to you as judges whether it does that today. When I sat in JSC, every day I heard it said, we need a high court in every county. There couldn't be a bigger fallacy than that. We don't need a high court in every county. In fact, we don't need more than a chief magistrate in half the counties. That is the fact. Something may look beautiful when you dream it, but it may not be practical if you want. There's so much clutter that we can remove from this Constitution, because we need to think about the economics of law. Law has a cost. We have 400 people in a house that has no quorum. Never, ever, ever has a quorum. When we were 210 people, there was no quorum. What have we? In theory, professors of constitutional law will say we have increased representation.
Prof, I'll interrupt you because you sound like you're making your closing remarks. We'll come to that. But let me take two very quick questions from that side. We are operating way beyond our time now.
I thought
and
we
will, just two questions from that end in quick succession. Yeah, please.
Okay, I have a question I have an issue with Githu Muigai's argument that when a judge is interpreting an issue to make a judgment, he should interpret it in a way that the decisions he comes up with should have a greater effect than the harm that has already been caused. You two have both agreed that politicians in Kenya are hooligans. There's a possibility that if judges interpret issues in such a way, the effect will be that politicians will be making decisions that do not follow the law, because they know that if they go to the courts will say that when they make their judgment, they'll say that if we interpret this issue in accordance with the law, the effect will be greater than the harm that has already been caused.
My name is Vance Wekesa, and as you pointed out rightly so, Dr. Mutunga, that there are other dispute resolution mechanisms. And I'm proud to say that I'm a professional mediator and an arbitrator to that effect. My question is one, but it's two-pronged. So allow me kindly, moderator, to ask it to both panelists. And the first one is directed to the Chief Justice Emeritus. And the question is quite direct. From what you've said, does ideological and political and religious biasness still play in the judiciary? In the judiciary. That is across board.
Yes.
Do you still see it in the judiciary and that will go to what Prof. Githu was talking about, the American system. Yeah. And my second question to you, still on the same, is what is the difference then to you between approaches in interpreting the law, the Constitution for that matter, versus the theory in interpreting the Constitution? And then the second question is directed to Prof. Githu Muigai. And thank you so much, sir, for being so articulate. And I'm tying this question with regard to what the Daktari said. Article 2.1 of the Constitution provides for the supremacy of the Constitution. Article 2.4 goes further to talk about the inconsistency of other laws or any other approaches in interpreting the Constitution, which would be null and void. And that also ties with Article 23A of the Constitution, which I believe Daktari was alluding to in the development of law. And thus my question, can judges make law according to you by virtue of Article 20? As the Chief Justice says, can judges make law? And, and secondly, this is last, what is your feel about the role of judges or the judiciary in transformation, if any? Because you said in the fullness of time, you believe in transformation. Okay. Yeah.
So yeah, there are divisions as you expect. Within the judiciary, differing ideological positions, political positions, which I think is a reality, and which, if the theory is developed then, and refined and accepted, judges won't have an opportunity to use those biases. Now, your second question was what? To me. Between approaches to interpretation versus the theory. Yeah, you write a dissertation on that question. Because if we start discussing theory and approaches, I suggest you read my writings on Githu's, right? And critique us. That's the important thing. You can write, a critique of this. Your Professor Mbote will give you all the documentation you need, and you know that It's actually the faculty of law that in 2013 that took the role of critiquing the petition, the presidential petition, got all the materials, and the university debated that. So we hope in future we'll be seeing dissertations coming from you guys, supporting or not supporting. That's what the academy is about. And if you write it, and you know, you can ask me that question, and then I'll give you a reading list of maybe 100 sources to go and deal with that issue.
Thank you. Thank you, Dr. Mutunga. To Prof, you had two questions. The first one, whether judges should make law.
Can I sit down?
I think that to provide a blank check for judges to make law is to undermine democracy in a very profound way. Judges have no business making law. What judges do, good judges do, what good judges should do, is creatively use legal principle, legal doctrine, legal rules to provide solutions. Very quick example, which I always give my students. Today in Kenya, we have no law on surrogate motherhood, in vitro fertilization, or related problems. We have a sperm donor, we have an egg donor, we have a womb donor. If I was a judge in Milimani and the three were fighting, I would not throw the file and say, there is no law, go to parliament and do it. I would go to contract law, I would find a doctrine. I would go to tort, I would find a doctrine. I would go to the Bill of Rights, I would find all these strands and I would put them together by legal reasoning, and I would give an answer. Am I making law? No. I am constructing from what law has already given me. So I've answered that one. The last one is, my good friend says, you know, Mwalimu, if you say that a judge shouldn't give an order whose effect is to create a worse situation than he faced, I stand by that. A judge should not be different from a surgeon. A surgeon never operates a patient whom he's not making better. Yep. A judge should not issue a legal order that makes the situation he's addressing worse. That's a prudential guidance. Let me give you, and this is my last example. As a young lecturer in this faculty, for the first time in the history of the faculty, there was a young lady who was about to get a first-class degree. Her aggregate marks was 69%. Her aggregate marks. My external examiner was William Twining. He's professor of jurisprudence at Oxford, and his father was last governor of Tanzania. And I told William Twining, do you mind if we have a moment outside the classroom? And we went there, and I told him, let's look at this mark sheet again. And we found 2 marks in the mark sheet, and we added them, and the young lady became the first person to get a first-class honors degree. The purpose... No, the first lady. I want to finish by saying our vocation is a vocation to do good. The vocation of law is to use law to do good. Thank you very much indeed.
Just before you sit, but you can actually take a quick rest. The final question and comment will come from Professor Wanjiku Kabira.
What was the, in terms of the 2/3, the Supreme Court decision, what informed the decision of the other judges, not in all the legal jargon and everything else, maybe in 30 seconds or so, because I know people are tired, and what informed yours? And how do you explain, those differences? Because it might give us an insight into what theories were they using, or what philosophy, and what was it, or what made it different from yours. And now I have to ask one question for Wanjiku. This woman from Mukabani, who went to the judge because she was being disinherited. And she was told that is not, I don't even know whose judge it was, but she was told to go back home because that is not in the realm of that particular judge. What do you do with that judge? Not with the woman. The woman has been disowned and gone back to the village, but the judge is left. And this is not the first one. There are many cases like those, particularly in relation to gender. Think of each area, you move from 50 to 25, you know, and those, yes. So how do you deal, how does the judiciary deal with judges that actually cannot find how to deal with gender-related issues, and they send us back to, you know, to where we want to get out of?
Thank you.
You know, I descended in the second 2/3 gender rule, and that is the first case when I started thinking about the theory of interpreting the Constitution, and I was looking at the history. You know, the history of discrimination against women, violence against women, the representation, and right up to 2010, and I formed the view that 1/3 is the minimum, and it had to be actually implemented there and then. The other judges said it was progressive, and they fixed a date, I think 15th of August 2015, for that to happen, and the rest is history. All right, but I was saying the provision, that provision had a history, had a reason, okay, and that reason, there was no basis for delaying, the implementation anymore. And of course, let me say it's the AG Emeritus who actually brought that case to the Supreme Court, obviously fearing, and rightly so, that if it wasn't progressive, Parliament would be unconstitutional. Okay, at that particular point. And in my judgment, I said it ought to be implemented immediately, and if it's not, Parliament will be unconstitutionally constituted. So, and I guess that's why I was saying judges also are politicians. I could feel the discrimination myself, and I knew that there was no, business for people to wait. And I think I was telling a professor here that if Parliament had 100 women under the Constitution, right, there will be enough numbers to beat up those men who are beating women there. But as long as there are just a few, they get attacked and whatever. So even the actual numbers, and the last thing I wanted to say is, I said that there was no point to discriminate against women who wanted to come to Parliament when you are not discriminating against the ones in the county. And my argument, again using the theory, was that the Constitution cannot have one section that subverts other sections. Yeah.
My view was then, as it is now, that we faced an existential threat to the Constitution at that time if we dissolved Parliament, the very Parliament that was to resolve the problem that existed. We would have created a situation. And again, it goes back to my own constitutional philosophy, which is that it is important to safeguard than to destroy. And I thought we would dodge that bullet, live another day, live to fight another day. I lived to fight another day. I left Sharia House without resolving the problem. I drafted 3 different bills, and they didn't succeed. I hear there is another effort to do it. I wish them all the best. Now, 2013, 2017 presidential election petitions, I was in both. I'm happy to say that Willy Mutunga's first decision was the correct one. It was, in my view, I expected some heckling from students, not from professors. And the reason for me was very, very straightforward. The procedure where you hear a case without taking evidence is a very special procedure, because then all the evidential questions that ordinarily should be addressed by the law of evidence are not. And earlier on we talked about the Supreme Court believing mostly that the Evidence Act is immaterial. The Evidence Act is fundamental to the probative value that you attach to what is alleged to be evidence. I believe the 2017 election petition, the first one, was made in vacuo. I thought it was wrong. Now, listen to this. This may help you now to understand my philosophy. I believe the second one that went to correct the first one was even more, the jurisprudence was more confused.
Thank you very much. On that note, we have to bring this to an end, and I want to give our two guests 2 minutes each to make closing remarks on a question that I have come up with. And that question is arising from their remarks, just their own remarks. To my right was Professor Githu, who said that, and held the Constitution and said that it contains a lot of clutter. It contains a lot of many necessities, unnecessary things. To my left was Dr. Mutunga, who, in my view, sounded unhappy with the extent of the implementation of the Constitution and certain provisions around it. Professor Githu, you did say that there are things in the Constitution that haunt you. Beautiful, but they haunt the country. And I want to ask you whether one of those things is the 1/3 gender concept, which up to now has failed to get implemented. And I want to start with Dr. Mutunga. You have 2 minutes to make your closing remarks on the question on whether 9 years, is it too early to talk of changing or overhauling this Constitution?
My personal view is that you can review a Constitution even after 5 years. As far as I'm concerned, it's the process, that I have issues with, where the Constitution is being changed through a process that undermines the former, processes. Because those former processes, we fought for them. Everybody knows that we fought for what is called people-based, constitution making. And that's how the word Wanjiku came in. If people remember, this was Moi saying, what does Wanjiku know about the Constitution? Because he wanted to bring in foreigners to write it for us. And we said, hell no. It's going to be written, by all of us. And that's how Wanjiku came in. He could, as we said, he could have mentioned any other person, but it showed that he thought that ordinary people are idiots. They can't write a constitution. But the processes showed that they have views about food, they have views about culture, they have views about everything. So it's a process that I think is important. It's not really the period, in my view.
Thank you. Professor Githu, you have 2 minutes.
I must say, on the gender issue, when we first started agitating around it for effecting changes, we had a lot of traction. We lost the public somewhere along the way because a perception developed that those who were already in parliament were not making a difference. I want to use the word perception because I don't share that view myself. We need to rethink how we get gender parity without the difficulties that we have now. And my solution is very simple if we came round to it. We now need to have constituencies with two, however we create them, 2 members, 1 male, 1 female. We leave that problem behind us. Whether it's the Senate, we have 1 county, 1 male, 1 female. We leave that problem behind us. What was the last point about?
Whether it's too soon to change the constitution.
I think it's never it's never too late to do the right thing, Martin Luther would have said. Well, if we all believe that there is a problem, I think the sooner we address it, the better. Last point, I promise you, Linus, this is my last one. In the design of the Constitution, again, we misled ourselves in believing that if you had a president elected by 50+1, that would resolve completely and totally the issue of legitimacy. We were wrong. We were wrong. And if I were to do it all over again, I would try to create a broader base for national leadership so that there is a bigger inclusivity provided by the Constitution itself. I would even go the Latin American way, put people in the Senate as senators, allow them all that sort of thing. Because what we now have is a situation where dominant political actors are shut out on the day after the election. And that creates political turbulence within the system that is unnecessary. There must be a way of inclusivity. I don't know how.
Thank you. Thank you very much. Attorney General Emeritus, Professor Githu Muigai, and Chief Justice Emeritus, the Honorable Dr. Willy Mutunga. Ladies and gentlemen, a very warm round of applause for these 2 great gentlemen. And that marks the end of our debate. I want to hand it back to Jennifer Githu and Dr. Collins Odote.